all the circumstances. So there's a broader exceptions for establishments of education whereby you've consented to be under them in the first instance. There's an automatic waiver of certain rights by association. When you associate yourself with someone or something, you are under their scrutinies and their private administration. Very important. New Jersey versus, I'll repeat that. A criminal activity can trigger a traffic stop if you're engaging in type of traffic related activity. But the traffic stop merely alone by itself without any other factors does not and cannot trigger a search. However, there are some exceptions, which we've run over in past videos, but it's just been summarized here. A warrantless search may be lawful. Put a colon in front of it to now list the criteria of what could justify a warrantless search. Summarizes the different types of properties, such as home, your own body, aka a person, locations or institutions for educations, such as schools, cars, and it provides pertinent case laws that have yet to be overruled. If the everyday man do not know these things, how can they ever speak up? But I can comprehend that it's difficult to speak up when you don't know certain caveats, certain exceptions, certain intricacies. But ultimately, it's far simpler than you think. In summary, consent is important. Hello, beautiful people. Welcome back. The one subject matter that will never get old is that of the Fourth Amendment. Fourth Amendment is one of the principles that highlights the necessity and importance of privacy within the federal Constitution. Granted, all the other amendments have as their backbone privacy behind it and the ability for a protected group of people or everyone in general who are not in governmental capacity to be protected and preserved, and the right to enforce said privacy to be protected and preserved, dependent on the means of expression, either the means of expression within the First Amendment, which is about 7 different rights, either the means of expression within the Second Amendment, which I trust many people already know with firearm, 3rd, 4th, 5th, 6th, all the way to the 10th, which are the Bills of Rights. I hyper focus on the Fourth Amendment because the Fourth Amendment encompasses most of the things that people hold dear and valuable. You and I are in the material world. Material things, whether we like it or not, are part of our daily activities. Even if you are a minimalist, that shirt you have on, those shoes you wear around, whatever you use as a place of abode is a material property that is acknowledged by the substantive law called the United States Constitution. And of course, it exists in your respective state constitution. And these properties range from personal, that are movable, to immovable. Here now is a compilation of the summary of many of the videos that we've been making so far when it comes to the loophole to the Fourth Amendment, which is Terry stop, which is an investigatory stop that is supposed to be short, outer layer for the purpose of seeking for firearm, and there must be a reasonable articulable suspicion rather than suspicion itself being the allegation of crime. All the way to the element of what probable cause is. That probable cause is a standard of evidence that is quite low compared to what most people think. And what qualifies probable cause based on the facts known to whoever is asserting the arrest or the indicia of reliability of a third party who complains of one thing or states that they witnessed something, all the way up to the totality of circumstance of the reasonable facts that's not subjective. We've spoken about all those in the past. This particular video somehow summarizes the different types of properties, such as home, your own body, aka a person, locations or institutions, the educations, such as schools, cars, and it provides pertinent case laws that have yet to be overruled. So according to the United States District Court website, they provide as follows. The Constitution, through the Fourth Amendment, meaning it's telling you, it's speaking about a very specific lens, which is through the Fourth Amendment, protects people from unreasonable searches and seizures. Now, let's pause here for a moment. This people, believe it or not, also involves business locations, which is also entertained in the United States Supreme Court case, New York versus Berger in 1987. But we're going to dedicate that to a separate video. But herein, I'm just letting you know that people is also generally categorized as business, so long as there's some natural persons behind it. The issue of artificial intelligence automating a business is an entire different world that is currently being entertained in Supreme Court and appeal cases in certain districts on federal and state level. So that's that with AI. And as it pertains to business, know that this people also encompasses business, so long as there's a natural person behind it, meaning of flesh and blood. But right now, we're just going to speak of people from the perspective of what you and I see as a immediate relatable condition of man, woman, old, young, someone who farts, piss, sneeze, laughs, cries, gives birth, have feelings, have emotion, passes away, and is subject to the nature's law of entropy. The Constitution, through Fourth Amendment, protects people from unreasonable searches and seizure by the government. This first sentence is letting you know that there are two folds of perspective that the Fourth Amendment deals with, whereby one is protected from the other. The everyday man, the people, are protected from the government in circumstances involving unreasonable searches and seizure. Unreasonable has its definition based on what type of encounter it is, which we went over in this video. In short, there are three main types of encounter with any type of governmental actors. And about 8 out of 10 times, most circumstances of searches and seizures involve some type of police power. But regardless of whether police power is involved or not, there are three main types of encounter. First is consensual. The second is a Terry stop. The third is the probable cause. If you know nothing about the nature of encounter between the people that are protected through the Fourth Amendment from, quote, the government, which is a body politic organized for the benefit of the people unless the people go to sleep, whereby the government now plays God over the people. Three main encounters: it's consensual, Terry stop, probable cause. Consensual encounters has nothing to do with Constitution, and you, just like it says, it's consensual. You don't have to interact in any way, and there is no liability conferred against you or assumed by you. Terry stop is a stepping stone to find issue, to engage in an actual formal arrest, which would give rise to probable cause. The Constitution, for the Fourth Amendment, protects people from unreasonable searches and seizures by the government. The Fourth Amendment, however, is not a guarantee against all searches and seizures. The Fourth Amendment, however, is not a guarantee against all searches and seizure. Recall a few minutes earlier where I mentioned Terry stop. which is search of outer layer for a short period of time, for search of weapons, so long as there's a reasonable articulable suspicion, whereby suspicion itself is not the crime that justifies the Terry stop, and it ought to occur for a short period of time. Those are the criteria of Terry stop. And the Fourth Amendment does not describe Terry stop because Terry stop is the loophole to it. This, however, whereby Fourth Amendment is not a guarantee against all searches and seizures, is telling you there are other type of searches. There are other types of seizures. By the way, seizures is just another word for arrest, whereby the Fourth Amendment is not implicated, whereby probable cause is not required. What do I mean by Fourth Amendment is not implicated by Terry stop? Well, here's the Fourth Amendment, which is the subject matter. The right of the people to be secured in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmations, which is usually the police report, and particularly describing the place to be searched, the person to be seized. In other words, no search or seizure can occur unless probable cause exists. And it's telling you here that there are other types of seizures whereby Fourth Amendment does not guarantee. Terry stop is one of those searches and seizures because Terry stop does not require an oath or affirmation that the Fourth Amendment speaks of. Terry stop does not require a probable cause for that brief stop to occur for a search of weapon, so long as there's a reasonable articulable suspicion that a crime has been committed, is currently being committed based on the fact observed by the one doing the arrest, and or is anticipated to occur based on the facts known, which would then give rise to probable cause to finalize the arrest and formalize the search by going into inner pockets, by putting people into custody and formally charging them with an assumption of a crime, whereby they now have to adjudicate it with the court venues within the appropriate jurisdiction to which the violation is being charged with. If it's a U.S. code, then the federal level. If it's the state common law, then it's state or county courthouses. In short, there are several types of seizures. Fourth Amendment is a probable cause seizure and search. Terry stop is part of the quote, all searches and seizures, whereby if it occurs indeed for a short period of time, whereby only outer layer of your pockets are searched for the purpose of finding a weapon based on anticipated crime, current crime observed based on the fact, or a crime that has occurred that you are part of, then it is not considered as Fourth Amendment. Once more, Fourth Amendment search and seizure is called a probable cause search and seizure, where there's a formal warrant, there's an affidavit, a said search and seizure particular to whoever the subject is. Terry stop, on the other hand, is a limited type of search. If the facts provide that the one being searched has in fact committed some type of crime, is currently doing so based on the fact, and is anticipated to engage in a crime based on observation of the facts of the one doing the arrest, or there is a weapon involved in a circumstance, and then the outer layer is searched only for a short period of time. That does not have Fourth Amendment implications, therefore does not require a warrant. That's what this first part of the second sentence refers to, where it says the Fourth Amendment, however, is not a guarantee against all searches and seizures, meaning they're telling you, look, there are other types of searches and seizures, which has just been explained over and over so that you really get what this refers to. You and I can read the same thing and we can get a completely different comprehension of it based on other things that are not readily and blatantly mentioned in what we are laying eyes on in black and white. That's why I'm explaining these things. That's why those prior videos, which thumbnails have been shown, were done in the past so that when you begin to read things like this, listen to these, think about these things, you see the full scope of the thinking behind the words of what's said without clearly using certain verbiages. The assumption is you're competent to a certain level when this was created. If you're not, you're just fooling yourself and you're misinterpreting what is and what is not. The Fourth Amendment, however, is not a guarantee against all searches and seizures, but only those that are deemed unreasonable under the law. The law, Fourth Amendment, and any state or federal legislation that are uniform with it, that is not contradicted, or else it is notwithstanding, as prescribed by Article 6 of said United States Constitution, where it says, "This Constitution, the laws of the United States which shall be made in pursuant thereof, and all treaties pursuant thereof, meaning in uniform with the United States, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land," meaning it's the foundation and it is the top layer that supersedes anything else, and everything else subsequent to it has to be uniform with it, aka pursuant thereof. And the judges in every state shall be bound thereby, anything in the constitutional law of any state to the contrary notwithstanding, and anything that opposes the principles that we've just read right here are to the contrary. That is the reason why I said Terror stop, which is the other types of seizures among these, quote, all searches and seizures, are the loophole. I refer to terror stop as loopholes because it's been justified since the people have kept quiet through res judicatas that we don't need a warrant to search you so long as the invasion of privacy is minimal and if it's for the purpose of public safety. That is where the search for the purpose of weapon comes in. That is where for the search if the crime was or is anticipated to occur. And that is a loophole considered reasonable because the invasion is, again, minimal and for the purpose of public safety. If someone says they're engaging in a terror stop and they're searching your inner pockets and there's no reason articulable because suspicion of a past, present, or anticipated crime, and it is not for the purpose of searching a weapon, then that is in fact unreasonable under the law. It now goes on to particular details, but summarizes first by stating whether a particular type of search is considered reasonable in the eyes of the law is determined by balancing two important interests. On one side of the scale is the intrusion on an individual's Fourth Amendment right, privacy right in short. On the other side of the scale are legitimate government interests, such as public safety, as aforementioned. The extent to which an individual is protected by the Fourth Amendment depends in part, meaning there's more, in part on the location of the search or seizure. They give the citation, Minnesota versus Carter, year 1998. Now they give you the specific types of places where there are or can be reasonable expectations of privacy. The home, person, schools, cars. Home, searches and seizures inside, not the curtilages, not based on plain view doctrine, not the sidewalk next to said home, but searches and seizures inside a home, meaning it will require some type of entry whereby a structure blocks the general public from plain view of what is within that location. Therefore, a reasonable expectation of privacy has been set. And usually consent will be required for such access, one way or the other. Whether you open a door, even if the door is unlocked, whether you open a gate, even if the gate is unlocked, whether you step into a place where people would consider to be a private space of comfort, even if there is no gate and there is no door. For instance, there are properties with outdoor showers. There are houses with garages whereby the garages don't have gates that lead to them. In some cases, some garages are attached to the property itself in a way whereby from the alleyway, you can see it, you can access it, you can touch it, you can inspect it one way or the other. And in some cases, some people have their garages open. Just because they have the garage open and you can see it or access it, does not remove the privacy itself, because said location is private. And some garages, given that they're attached to the home and they lead directly physically into the home, it creates some expectation of privacy that's far beyond curtilages and Plainview doctrine. Searches and seizures inside a home without a warrant are presumably unreasonable. Payton versus New York, 1980. However, there are some exceptions, which we've went over in past videos, but it's just been summarized here. A warrantless search may be lawful. Put a colon in front of it to now list the criteria of what could justify a warrantless search. A warrantless search may be lawful if an officer is given a consent to search. That's one. Your consent to search will waive any given right you have, because your ability to preserve and enforce a right that's been preserved in writing can be waived by you. And the moment you waive it, it is as though you said, yep, go ahead, do as thy will. If an officer is given consent to search, a warrantless search may be lawful. Davis versus the United States, 1946. If the search is incident to a lawful arrest, meaning a probable cause that exists and a warrant existed, therefore you were seized, aka you were arrested. If there's a use of force or tone or presentment of the warrant whereby you know that, okay, you can't physically leave, then you've been arrested. And then if they search you, consequently, aka search incident to lawful arrest, then it is lawful. But remember, the particularity here is a warrantless search. If they had no warrant and the Terry stop was engaged in and a weapon was found, or there are facts supporting that the one that was seized, aka arrested, had in fact engaged in a crime, such as evidence of forceful break into a property, whether it be a vehicle or a home, such as some blood and the trail of blood, whatever it is that can be corroborated outside of subjective opinions. And from that, regardless of whether they have a warrantless arrest or search, remember the mentioned up here issue of public safety, which is considered legitimate governmental interest. So if there is a warrantless search based on a Terry stop and there is in fact evidence of a past, current, or anticipated crime, then that is lawful. If there is probable cause to search and exigent circumstances, we went over exigent circumstances in this video right here. Exigent circumstances are just emergency situation, fight or flight circumstances where evidences can be destroyed, or the man or woman impose a danger to society and escalate the circumstance. Even though most of us know, based on the technological luxury and opportunity that reveals most activities of municipal employees that are armed, that 9 out of 10 circumstances are in fact escalated by those who are armed employees of entities. And lastly, as it pertains to homes, if the item are in plain view, Maryland versus McCon, 1985. This is plain view doctrine that's been spoken of. In other words, your privacy is yours to protect, enforce, preserve. Just because that word privacy implies or somehow in some way denotes the integrity of something or you being kept absent of other influence or external influence does not mean you should not protect it. Just saying privacy, privacy, privacy is not enough. You have to protect privacy because it's a right that in some circumstance is not self-executing. You have to create that reasonable expectation of privacy. That's the formal term, reasonable expectation of privacy. So that's that with home. When it comes to Fourth Amendment requirement, and how it can be waived. Now to a person. When an officer observes unusual conduct, which leads him reasonably to conclude that criminal activity may be afoot, in anticipation of a criminal act, the officer may briefly, this is Terry stop, may briefly stop the suspicious person. The suspicion is not the crime, but the observation of the anticipation of criminal activity is. And that has to be reasonably articulated so that an informed decision can be made as to the nature of the stop, which you can use as an affirmative defense if you don't know what's going on and deem it a consensual encounter. If an investigatory stop, aka Terry stop, aka a reasonable conclusion of criminal activity and a subsequent search, is not evoked by the one saying they're stopping you. And in most states, you will find that the legislative languages say that they have to inform you of who they are and what they are doing for Terry stop to be valid, aka stop and frisk, aka stop and ID. And those stop and frisk and stop and ID is implemented into different codes. For some state, it's implemented into trespass. For some state, it's implemented into obstruction statutes. In some states, it's particularized as temporary stop and identification. They dedicate a specific section to it. In some case, stop and frisk is only applicable to certain classes of crimes and whatnot. In some states, it's just general. In some states, don't even have stop and frisk at all. So you'll have to look at your particular case. And where it does apply one way or the other, it is when an officer observes unusual conduct, and in fact must be known that relates or lead him reasonably to conclude that criminal activity may be afoot. And it already occurred, it's occurring, was about to. The officer may briefly stop the suspicious person and make reasonable inquiries. Reasonable inquiries. The criteria of what makes Terry stop reasonable is what's been mentioned earlier. Part of it is being brief. Again, the suspicion itself is not the crime. And what makes the suspicion reasonable is the articulation of an actual criminal activity that they suspect is occurring, not just that the man or woman looks suspicious. That's subjective. May briefly stop the suspicious person and make reasonable inquiries aimed at confirming or dispelling the officer's suspicion. Good old Terry versus Ohio, 1968, and also Minnesota versus Dickerson, 1993. Now on to schools. School officials need not obtain a warrant before searching a student who is under their authority, meaning under their jurisdiction, under their consent, under their property, as a subsidiary of their property, as an extension of their property by virtue of consenting to be part of their establishment. That's what this is telling you. School officials need not obtain a warrant before searching a student who is under their authority. This can be the principal, this can be the teacher. Rather, a search of a student need only be reasonable under all the circumstances. So there's a broader exceptions for establishments of education whereby you've consented to be under them in the first instance. There's an automatic waiver of certain rights by association. When you associate yourself with someone or something, you are under their scrutinies and their private administration. Very important. There's an automatic waiver of certain rights by association. When you associate yourself with someone or something, you are under their scrutinies and their private administration. Very important. There's an automatic waiver of certain rights by association. When you associate yourself with someone or something, you are under their scrutinies and their private administration. Very important. New Jersey versus TLO, 1985. Cars. Where there is probable cause to believe that a vehicle contains evidence of a criminal activity. Where there is probable cause that a vehicle contain evidence. Remember, probable cause is a standard of evidence of a criminal activity. An officer may lawfully search any area of the vehicle in which the evidence might be found. In other words, for a search to occur with a vehicle, there has to be a probable cause. There has to be a probable cause. There has to be a probable cause of evidence relating to criminal activity, meaning there has to be fact relating to that probable cause, not just a hunch, not just solely by virtue of a traffic stop itself. Can a traffic stop be used as a stepping stone to a criminal search? Sure, but even in that case, there still has to be a probable cause for that alleged criminal evidence to trigger a search, not just merely the traffic stop itself being the cause for the search. Arizona versus Grant, 2009. An officer may conduct a traffic stop. An officer may conduct a traffic stop if he has reasonable suspicion that a traffic violation has occurred. An officer may conduct a traffic stop, in other words, a seizure, whenever you know that you cannot leave, either through the emergency light, which is a form of show of force, a show of authority, or someone commanding you to do so through pulling out a firearm, or whatever the circumstance may be, a roadblock, whatever it is. An officer may conduct a traffic stop if he has reasonable suspicion that a traffic violation, so the stop for the traffic is related to traffic violation, or that criminal activity is afoot. Now let's pause for a moment. If you pay attention, you realize that a criminal activity can trigger a traffic stop, but a traffic stop itself is not the sole requirement to trigger a search itself. I'll repeat that. A criminal activity can trigger a traffic stop if you're engaging in type of traffic related activity, aka using any movable machinery. Criminal activity can trigger the stop, but the traffic stop merely alone by itself, without any other factors, does not and cannot trigger a search. Berkmer versus McCarty, 1984, United States versus Arvizu, 2002. An officer may conduct a pat down, aka Terry stop, of the driver and the passengers during a lawful traffic stop. The police need not believe that any occupant in the vehicle is involved in a criminal activity. Here now is the reason why I'm actually reading this website. See, everything else we've read up to this point is almost like a primer, really. The highlight of this whole thing is now this. Remember, we went over what pat down, aka Terry stop is. We went over probable causes. We went over what traffic stops are. Listen to this carefully now. An officer may conduct a pat down, aka Terry stop, of the driver and passengers during a lawful traffic stop. Remember, a search that requires probable cause cannot be triggered by traffic stop itself. A search that requires probable cause cannot be triggered by traffic stop itself. A search that requires probable cause cannot be triggered by traffic stop itself. A search that requires probable cause cannot be triggered by traffic stop itself. But a Terry stop can occur and can be triggered merely by traffic stop itself. Extremely important for you to realize. A traffic stop does not trigger a search, but a traffic stop can trigger a brief stop, a pat down, a brief non-invasive search, aka pat down. If that non-invasive search is not just a simple pat down, then know that that has exceeded the performance of what the lawful authority is, and that at that point is an unlawful stop. An officer may conduct a pat down of the driver and passengers during a lawful traffic stop, assuming the traffic stop itself is lawful in the first place. The limits of the type of search that can occur is just a pat down. Assuming the traffic stop itself is lawful in the first place, the limits of the type of search that can occur is just a pat down. Assuming the traffic stop itself is lawful in the first place, the limits of the type of search that can occur is just a pat down. Not the search of under your seat, the back, the vehicle, the pockets, all that. No, just the pat down outer layer. Not the search of under your seat, the back, the vehicle, the pockets, all that. No, just the pat down outer layer. Not the search of under your seat, the back, the vehicle, the pockets, all that. No, just the pat down outer layer. Police did not believe that any occupant of the vehicle is involved in a criminal activity. When it comes to traffic matters, there's no requirement of anticipated crime for pat down to occur. Absent of traffic matter, there is a requirement of past, present, or anticipated criminal activity for a pat down to occur. Therein lies the two main difference between the pat down for traffic stops and pat downs that are not traffic stop related. When it comes to traffic matters, there's no requirement of anticipated crime for pat down to occur. Absent of traffic matter, there is a requirement of past, present, or anticipated criminal activity for a pat down to occur. Therein lies the two main difference between the pat down for traffic stops and pat downs that are not traffic stop related. When it comes to traffic matters, there's no requirement of anticipated crime for pat down to occur. Absent of traffic matter, there is a requirement of past, present, or anticipated criminal activity for a pat down to occur. Therein lies the two main difference between the pat down for traffic stops and pat downs that are not traffic stop related. This is very important for people to know. It then goes on to say the use of narcotics detection dog to walk around the exterior of a car subject to a valid traffic stop does not require reasonable, explainable suspicion. Exterior of the vehicle, that is. The moment the sniffing dog is engaging in the interior of the vehicle, then that stop is unlawful. But even this is subjective. Even this can be disputed, and there are some case laws that actually speaks of different circumstances but does not directly counter this case law, because dog's sense of smell can effectively search past the exterior, which is the inside of it. Even a human nose can smell things from other people's houses, other people's vehicle, without them opening the door. Especially a dog whose sense of smell is many times fold more sensitive than that of humans, effectively searching the interior of their vehicle just from the outside. And there are many other case laws to deal with that also. So that's the caveat for this particular one when it comes to narcotic detection dog. Special law enforcement concerns will sometimes justify highway stops without any individualized suspicion. Special law enforcement concerns, such as the T word, such as the good old public safety thing like some chase or someone being trafficked and they don't know the particular man or woman's vehicle, so and so. And more details provided in this case law. Maybe in the future we'll go into it. But as for now, we're just going to stick to this website and go over this list so we don't make this video too long. Next, an officer at an international border, whether that's through airports or physical vehicles still on land. An officer at an international border may conduct routine stops and searches. United States versus Montoya de Hernandez, 1985. Another reason why this video is made on this website. When it comes to international transitions of one jurisdiction to the other, the assumption is that the requirement of warrant for searches and seizures to occur is waived. Know that. Although there are certain limitations, which is also entertained within this case law. A state may use highway sobriety checkpoint for the purpose of combating drunk driving and, in short, public safety. Michigan Department of State Police versus Sitz, 1990. A state may set up highway checkpoints. A state may set up highway checkpoint In other words, it will be determined by the common law of the state, aka the compiled statute, whatever laws, general laws, slip laws of the state. A state may set up highway checkpoints where the stops are brief and seek voluntary cooperation in the investigation of recent crimes that have occurred on that highway. I think that's self-explanatory without any of the further details. Illinois versus Lidster, 2004. However, a state may not use highway checkpoint programs, which are voluntary and must be brief, whose primary purpose is the discovery and interdiction of illegal narcotics. Meaning, out of the thousands and possibly hundreds of thousands of people moving about a given highway every day, it can be said that, well, there are chances that about 10 or 100 or 1,000 of them will have narcotics. Therefore, we're just going to stop everyone and just delay their daily life activity, the flow of traffic, a highway. Even though you and I know we see that every now and then, where some moron just parks the municipal vehicle in the middle of the road and hinders traffic just because he or she feels they can. And they do so for hours on end. Especially in certain jurisdictions like New York, California, they're quite notorious for just arbitrary performances like that. But if the everyday man do not know these things, how can they ever speak up? But I can comprehend that it's difficult to speak up when you don't know certain caveats, certain exceptions, certain intricacies. But ultimately, it's far simpler than you think. In summary, consent is important.